Hello and welcome to the Entrant. The topic for today's discussion is nature of the Indian Constitution. This topic holds great importance when it comes to questions asked in the competitive exams. Before delving into the subject matter, let us understand a little about the Constitution itself. A constitution is a document which lays down the basic principles and laws of a state and determines the powers and duties of a government. Basically, it is a legal document stating how a government is supposed to work. It gives us the provisions on how to elect our leaders and states the procedure for introducing new laws or amending the old ones. Now that we know what a constitution is, we move on to the nature of the Indian Constitution. Traditionally, constitutions have been categorized into two forms by the political scientists. Therefore, they are either unitary or federal. In a unitary constitution, the powers of the government is centralized. That is, the central government is supreme. For example, France, South Korea, UK, etc. Whereas in a federal system, the power is divided between the federal and the state government, which is the center and the states. USA is an example. But in the case of the Indian Constitution, there is a difference of opinion amongst the constitutional jurists. One side argues that it is a federal constitution, whereas the other side argues that it is a quasi-federal system with more unitary features. To do away with this confusion, we have to understand what a federal constitution is and whether our constitution has these characteristics. We also need to understand what other features does our constitution possess that makes it so different from a federal constitution. The basic principle of federalism is division of power. The center and the state work together and are independent in their spheres. They are not subordinate to each other. A federal constitution has 5 characteristics. Let's look at them. First, distribution of power. Power is distributed between the center and the state, where matters of national importance in which uniform policy is desirable, authority is entrusted to the union, and matters of local concern remain with the states. Second, supremacy of constitution. A federal state obtains its power and existence from the constitution. Therefore, every executive, legislative, or judicial power is subordinate and controlled by the constitution. Third, a written constitution. The foundation of a federal state are complicated contracts. To maintain the supremacy of the constitution, the terms of the constitution have to be in writing. Fourth, rigidity of the constitution. A natural consequence of a written constitution is its rigidity. In this, the procedure of amendment or the process through which old laws are changed or new laws are implemented is very complicated and difficult. Fifth, authority of courts. To maintain the division of power, an independent and impartial authority should exist under the Constitution. The judiciary has the final power to interpret and guard the provisions of the Constitution. Now, looking at these characteristics, we know that India possesses all of them. India has a system of dual government. There is a division of power between center and state. The Constitution is written and supreme, and the Constitution of India establishes a Supreme Court which has the final power to interpret it. But still, some scholars hesitate to call it federal. Let's see what features or modifications make it so different. First, union of states. The word federation has nowhere been mentioned in the Indian Constitution. Furthermore, Article 1 of the Indian Constitution states that India, that is Bharat, shall be a union of states. Second, appointment of governors. Article 155 gives the power to the President to appoint governors to the various states. They are also answerable to the President. But the governor is only the constitutional head of the state and normally acts on the advice of his ministers. But there are certain provisions under which the governor is required to send certain state laws for the assent of the president. The president, under Article 200, 201, and 288, subclause 2 of the Constitution, has the power to veto those state laws. Third, single citizenship. In India, there is only single citizenship. There is no state citizenship. Irrespective of the place of residence, all citizens enjoy the same rights. Fourth, Parliament's power to legislate in national interest. Article 249 gives the Parliament the power to enact or make laws with respect to every matter given in the state list if the Rajya Sabha passes a resolution by 2/3 majority, making it necessary for national interest. This law remains in force for 1.5 years. That is, the law will cease to have any effect 6 months after the resolution comes to an end because the resolution remains in force for 1 year. This power of the Parliament is used only during national emergencies. Therefore, if we look at it objectively, Article 249 does not place the state in a subordinate position as the resolution is supported by the Council of States itself. Fifth, Parliament's power to form new states and alter boundaries of existing ones. Article 2 and Article 3 gives power to the Parliament to redraw the political map of India, to create and abolish the names of the state, alter the boundaries of the state, or even change their names through a simple majority of the Parliament. The state assemblies can only provide consultation. For example, in the division of Andhra Pradesh into Telangana, the state assembly had opposed the separation by passing a resolution, but the central government continued with it. Sixth, emergency provisions. There is a vital change in the relationship between the center and the state when emergency is declared. Under Article 356 of the Indian Constitution, the state government can be either dismissed or the state assembly can be kept in suspension. Thus, the power lies with the center during times of emergencies. With this, we come to the conclusion that India has a federal constitution with strong centralizing tendencies. It works as a federal system during normal functioning but becomes unitary only during times of emergencies. We must understand that federalism varies from place to place and from time to time depending on many factors such as historical, geographical, economic, and political. Federalism is a dynamic concept which can be adopted to suit the needs of a country. Therefore, India's form of federalism is not necessarily less or wrong in nature. It is just different, unique, and custom fit for its own circumstances. I hope this video was helpful in providing a simple and clear understanding of the nature of the Indian Constitution. For further queries, please drop your questions in the comment box below. And don't forget to like, share, and subscribe. Thank you.